Alright, buckle up because this courtroom drama is about to take you on a wild ride. Meet Serrano Johnson, a man accused of violating his bond by drinking alcohol. Sounds simple, right? Just wait until you hear the judge break down Johnson's ridiculous math about how many non-alcoholic beers he'd need to get drunk. Trust me, you don't want to miss this.
Court does call the case People versus Serrano Johnson. Presumably, he has indicated that he had old duels. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That is correct, Your Honor.
And here it is. The unraveling begins. The judge just called out Johnson for the classic omission confession. First, he claims he only drank O'Doul's, then casually admits to actual beer. This is a huge moment. In court, omission isn't just forgetting, it's misleading. And for someone on bond, this is a dangerous game. What would you do in his shoes? Own up or double down? Let us know in the comments.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No. Hey,
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got you.
Story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
An hour without a single bathroom break. That's not just unbelievable, it's biologically impossible. This isn't just sarcasm from the bench, it's a surgical takedown of a lie. And when a judge starts doing math to prove you're lying, you're in trouble.
That's how stupid your story was. And now you can't even bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause contract, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
Well, I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really? No, he was not being honest. I asked him the question. And then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has itself.
Here's where the truth finally trickles out. Pun intended. Johnson admits he lied out of fear. But here's the kicker. Fear doesn't excuse dishonesty in court. It only stacks the consequences. The judge knows this, the attorneys know this, and now so do we. Honesty might hurt short term, but deception in court always backfires harder. Would you have come clean earlier? Drop your thoughts below.
And he wants to get help for that. He's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a SCRAM tether. Again, this would be his first violation. And he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I do.
The way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
Address bond, Your Honor.
Well, what are we going to be doing with the case first?
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the probable cause.
Yes, Your Honor.
I'll give you a date and moment depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles, the pastor.
Outright lied. That's a strong statement on the record. And when your own lawyer has to stand there and admit that, it speaks volumes. Notice how the defense tries to pivot to character references. Volunteering, being a caregiver, admirable, yes. But in the face of dishonesty, will it be enough to sway the judge? Keep watching.
It's outright lied.
Well, I wasn't there.
That makes it no less a lie.
I'm asking if you want to hear from me.
I'll
A humble apology.
I will certainly hear from him, but not if he's gonna sort of spew that garbage he was given me the last time, because that's how he ended up in custody. So on the date that you drank, what happened?
What was the trigger? What made you?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so
So
did you have any O'Douls
at first, but
at first? Okay. How many O'Douls did you have? 6. And then you had how many? Would have had to have a little over a case of O'Douls. Remember that?
yes.
Then, at that point, you realize, well, he looks stupid, but he's not. And then you started telling me that you had 2 beers. Remember that? What?
Yes, sure.
And I knew, given the level that's on here, that wasn't true. Me that you were in treatment or had started treatment.
We were looking for a place to go to treatment. That's where we're starting. We're trying to go. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
of Johnson's original claim and uses biology, logic, and a splash of sarcasm to shred it. The moment the judge says, "That was kind of the stupidity of the lie," you know Johnson's credibility is toast. This is a textbook example of how not to talk to a judge. Let's be honest, how would you have handled it differently?
Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was going to happen with those rules.
To get a definite yes, it will cover some sort of treatment. Yep.
Anything from the people.
Your Honor, the people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person. At no point that we allege that. We're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think without treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concerns.
I'm going to first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a SCRAM tether, because you were on a
Correct.
You're going to go on a SCRAM tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that
Of truth in the courtroom. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I do.
Thank you.
Thank you, Your Honor.
No, this will do that. Okay. Thank you, sir. Because you were on a
Correct.
gonna go on a SCRAM tether, so I'm gonna monitor you 24/7 for any alcohol consumption. I'm also gonna order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that, and the prosecutor's office, that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm gonna issue a warrant and I'm gonna have him picked up.
Understood.
You understand all of that, sir?